Hello, my name is Wlodyka, and I'm a partner with Direction Legal LLP. Today I will be talking about what you can do when Canada Immigration says no to an application that you or your family members has made. The information in this video covers a wide range of application processes, such as a work permit, a study permit, an independent permanent resident application, a sponsorship application of a family member to come to Canada, a renewal of permanent resident status, or a citizenship application, or even a refugee claim, just to name a few. Regardless of the type of application that was denied by Citizenship and Immigration Canada, you do have the option of challenging that decision. Citizenship and Immigration Canada is not infallible. They make big mistakes in the process of making their decisions, and those decisions can be reviewed and overturned. You would do this through an appeal or judicial review process. The independent body you would appeal to depends on the type of application you have submitted. For example, an appeal of a negative decision of a sponsorship application is processed through the Immigration and Refugee Board. However, where the negative decision concerns a citizenship application or an application for a work permit, study permit, or an independent immigrant visa, you would need to retain a lawyer to challenge the decision in the Federal Court of Canada. An appeal or judicial review can be critical to an applicant for two reasons. First, if the appeal or judicial review is successful, Citizenship and Immigration Canada will have to look at the application again and correct any mistake that its officials made. In many cases, this is enough to obtain the result that you want. Second, the repercussions of not challenging the negative decision are serious. A negative decision on an application is like a criminal record. You will need to disclose it in any subsequent application, and the previous negative decision may influence the immigration officer to refuse your application again. The stakes in any immigration or citizenship application are very high, and a negative response should not be taken lightly. It is also important to note that there are time limits for challenging the negative decision. In most instances, you only have somewhere between 15 and 60 days, depending on the particular application that is involved. An experienced immigration lawyer will be able to tell you the amount of time you have to challenge a decision and the chances of a successful outcome. Sometimes the lawyer will need to obtain the client's entire file from Canada Immigration to determine the chances of success. The lawyers at Direction Legal are very proactive in keeping up with the rapid changes in the immigration and citizenship law. We understand the impact that a negative ruling on an application may have on a person's life, and that there are deadlines to be met to initiate any challenge to the negative ruling by an immigration or citizenship officer. We understand the appeal or judicial review processes involved and how to use those processes to the best advantage of our clients. I have over 35 years of experience in dealing with all kinds of immigration and citizenship applications, appeals and judicial reviews. I've taken cases all the way to the Supreme Court of Canada. I was a decision maker and assistant deputy chairperson with the Immigration and Refugee Board. I have a unique perspective because I understand the appeal process from both sides. Direction Legal also offers to conduct appeals or judicial reviews for a fixed fee and with a reasonable payment schedule. In summary, we offer expertise, experience, cost predictability, and installment payments. If you or someone you know needs help with an immigration or citizenship application that has been refused, feel free to contact us. We are here to help you.